Good morning, sir. What are you doing out here?
Taking the trash, man. That's my route.
We had some calls about someone hanging around the area. You match the description.
I'm not hanging around. I'm working. City sanitation. See the truck?
I hear you, but I'm telling you, finish up and move along. Otherwise, this could turn into arrest.
I'm employed by the council. I got every right to be here.
Sir.
The city paid $3,700,000. That number is not an accident. It is not a rounding error. It is a legal conclusion, a monetary verdict on what happened on a quiet residential street on the morning of December 22, 2024, when a man doing his job became the subject of an arrest that would ultimately fail every test the law put to it. But that number did not appear out of nowhere. It came after a man in a reflective vest was forced to the ground beside his own garbage truck. It came after handcuffs were placed on someone who, moments earlier, was lifting trash bins in broad daylight. And it came after bodycam footage captured every second of a decision that would not survive legal scrutiny. Before we break down the law, watch what actually happens. A city worker in a neon vest standing beside a marked truck, about to be told he does not belong where he was assigned to work. This is not a story about outrage. This is a story about procedure, about constitutional boundaries, and about what happens when the authority to enforce the law collides with the limits of that authority. Watch closely, because the details matter more than the drama. At approximately 10 minutes past 10 in the morning, the body cam activates. The footage is steady. The street is unremarkable, lined with residential homes, bare winter trees, and the kind of quiet that comes with a Sunday-adjacent holiday week. At the curb, a city sanitation truck sits with its hazard lights blinking in slow rhythm. A man in a high-visibility vest is working the bins along the roadside, moving with the practiced efficiency of someone who has done this exact route dozens of times before. The officer approaches at a measured pace. Nothing about his initial body language signals emergency. His hands are relaxed. His voice, when he speaks, is conversational. He tells the worker there has been a report. Someone in the neighborhood called about a person loitering and looking around properties. That is the origin point of everything that follows. A phone call, a characterization, and a moment when what the officer could see with his own eyes should have resolved the question before it became a confrontation. Because visible in the frame, clearly, is the garbage truck. The worker responds immediately. He identifies himself as a city employee. He is not evasive. He is not aggressive. He explains his role, his route, his purpose on that street at that hour. He gestures toward the truck. The uniform he is wearing carries municipal insignia. There is no ambiguity in the scene for a trained observer. This is a sanitation worker, mid-route, doing precisely what the city scheduled him to do. That purpose is documented, assigned, and publicly visible. This was not his first time on this street. This was a scheduled route. Same truck, same block, same procedure. Nothing about this morning suggested it would end in handcuffs. And yet the officer tells him to leave, not to wait, not to produce identification, not to stand by while a supervisor is contacted, to leave, to abandon his assigned route, his equipment, and his professional obligation, and to go somewhere else. The worker does not comply. He returns to collecting trash. That decision to continue working becomes the legal hinge point of everything that follows. Because what happens next is not de-escalation, it is escalation. The officer's tone shifts. The language becomes directive and absolute. The officer is told again to leave. He explains again that he cannot simply abandon city property and a municipal assignment without authorization. The officer does not contact the sanitation department. He does not radio for clarification on whether a work order exists for this block. He makes a field determination. There is a critical decision point here. Every encounter has one. This was it. Investigate or enforce, clarify or command. The path chosen in these next seconds is what turned a routine call into a constitutional problem. And within minutes, that determination becomes physical. The worker is detained, he is taken to the ground, and he is charged with loitering, disobeying a lawful order, and negligence. Now let us slow down and examine what the law actually says about each of those moments. Pause the footage here. Look at the frame. You see the truck, you see the vest, you hear the explanation. Ask yourself a simple question. What specific crime is visible in this moment? Because that question is exactly what a court would later ask. Loitering, as a legal standard, requires that a person be present in a location without apparent purpose in a manner that creates reasonable concern. A sanitation worker mid-route, beside a city vehicle, in a high-visibility uniform, collecting roadside refuse, is not loitering. Under those conditions, loitering as a charge does not survive basic legal scrutiny. Which brings us to the lawful order.
For an order to be lawful, it must be grounded in lawful authority. An officer can order a person to move if there is a genuine public safety concern, if the person is obstructing traffic or an investigation, or if the officer has reasonable, articulable suspicion that a crime is occurring or about to occur. Reasonable suspicion is not a rumor. It is not a neighbor's phone call interpreted at face value without independent observation. It is a standard that requires the officer to point to specific, objective facts that, taken together, justify the belief that something unlawful is happening. The garbage truck, the uniform, the worker's immediate and credible explanation, those facts point in one direction. They do not support suspicion, they resolve it. An officer does not have the authority to order a city employee off a public roadway simply because a resident made a call. That is not how reasonable suspicion works. That is not how lawful orders work. And courts have been clear on this point. If the order itself lacks lawful foundation, then non-compliance with that order is not a criminal act. You cannot be lawfully arrested for failing to obey an unlawful command. This is a distinction the law takes seriously, and one that juries and civil courts take seriously as well. Now consider the escalation itself. Watch the footage again through a procedural lens. At what point does the officer pursue clarification versus confrontation? At what point is a supervisor contacted? At what point is dispatch asked to verify whether a sanitation route exists for this block on this morning? None of those steps appear in the record. What appears instead is a pattern familiar to attorneys who litigate civil rights cases, an officer who has made a determination and is now enforcing that determination rather than investigating it. The worker, for his part, does not run. He does not become combative. He does not threaten. He states his position, returns to his task, and by every visible measure behaves as a person who believes, correctly, that he has the right to be where he is, doing what he was assigned to do. If you value objective breakdowns of bodycam footage, not outrage, just facts and constitutional analysis, subscribe to the channel, and comment below where you're watching from. Transparency only works when the public stays informed. That is not resistance. That is not obstruction. That is a person asserting a lawful presence. And the legal distinction between non-compliance and active resistance is not a technicality. It is a constitutional boundary. Non-compliance with an unlawful order is protected conduct. Active resistance to a lawful arrest is a different matter entirely. The law does not treat them the same, and neither do the courts. On the Fourth Amendment side of this case, the analysis becomes even more consequential. The Fourth Amendment protects against unreasonable seizures of persons. A detention, even a temporary one, is a seizure. It requires justification. That justification must exist at the moment of the detention, not be constructed afterward. When a court examines whether this detention was lawful, It applies an objective standard. Would a reasonable officer, looking at the totality of the circumstances, have had sufficient legal basis to detain this individual? The garbage truck in the frame is not a footnote. It is evidence, and it cuts directly against the legal foundation of the stop. False arrest under federal civil rights law, specifically Section 1983 of Title 42 of the United States Code, requires a plaintiff to show that an officer deprived them of a constitutional right while acting under color of law. The plaintiff does not need to prove malice. They need to prove the absence of probable cause. Probable cause is a higher bar than reasonable suspicion, but it is the bar required for an arrest. Given what the body cam shows, meeting that bar becomes extremely difficult for the defense.
Qualified immunity is the doctrine that officers often invoke to shield themselves from personal civil liability. It protects officers from suit unless they violated a clearly established constitutional right, and it does not protect against the kind of conduct that is, as courts phrase it, objectively unreasonable. When the facts visible on the officer's own recording contradict the legal basis for the arrest, qualified immunity arguments face significant headwinds. Municipal liability enters the picture when conduct reflects not just an individual officer's decision, but a pattern, a policy, or a failure to train. Cities can be held liable when they have created conditions under which constitutional violations become predictable. Whether this incident reflected a systemic failure or a single catastrophic misjudgment, the city's legal team ultimately evaluated the evidence and made a calculation. They settled. After the arrest, the worker was processed and held. Hours passed in a holding facility that had no business containing him. The charges did not strengthen with time, they weakened. By the time he was released, the legal architecture of the case against him had already begun to collapse under its own weight. There was no crime. There was no scene of unlawful conduct. There was a man, in a vest, beside a truck, doing a job, and the paperwork that tried to make that into a criminal act could not bear the scrutiny that followed. The civil lawsuit filed in the aftermath made several claims: lost wages for the period of suspension and legal proceeding, emotional distress, which courts recognize as a legitimate and compensable injury when it results from unlawful government conduct, reputational harm, because an arrest, even one that does not result in conviction, leaves a record, affects employment standing, and alters how a person is perceived in their professional community. And constitutional damages, because the violation of a person's Fourth Amendment rights carries independent legal weight. $3,700,000 is not symbolic. It reflects risk assessment. It reflects the strength of the footage. It reflects what city attorneys believed a jury might do if they saw this encounter frame by frame. Municipal settlements of this size do not happen because a case is weak. They happen because the evidence is strong. Municipalities settle cases for several reasons, and they are rarely simple ones. Settlement avoids the cost and unpredictability of trial. It avoids the public record of a verdict. It avoids the possibility of a jury seeing that body cam footage and returning a number higher than what the city's attorneys offered. Settlement is not an admission of guilt under the terms of most agreements, but in the court of legal and public analysis, a settlement of this magnitude communicates something unmistakable. It communicates that the case put before a jury carried substantial risk.
Now consider what this case teaches, not as a cautionary tale delivered with alarm, but as a structured set of principles that apply to anyone who lives and works in public spaces under the authority of government. The first lesson is this: know your rights during a police encounter. If you are stopped by police while working, identify yourself clearly and calmly. State your employer, your role, and your purpose. If you have documentation, an employee ID, a work order, a visible uniform, make it visible. You are not required to answer every question, but offering your professional context immediately is both your right and your protection. Clarity in that first 30 seconds can change the trajectory of an entire encounter. The second lesson: lawful authority requires lawful order. An officer can ask you to move. An officer can ask you to stop. But those requests become enforceable commands only when they are grounded in a legal basis. If you believe an order is unlawful, the appropriate response is not physical resistance. It is verbal, clear, and documented objection. State that you believe the order is unlawful. Do not physically resist. Let the legal system do the work that it is designed to do. The third lesson is about documentation. If your employer issues GPS-tracked routes, login systems, or assignment records, those records become evidentiary gold in disputes like this one. Workers should understand that their employment records are not just administrative paperwork. They are their legal shield. In a case where presence is questioned, a time-stamped work order answers that question before it becomes a charge. The fourth lesson belongs to everyone on both sides of these encounters. Bodycam footage is a two-edged instrument. It protects civilians when officers act unlawfully. It protects officers when civilians make false claims. In this case, the footage did not protect the officer because the footage showed what it showed: the truck, the uniform, the explanation, the escalation. Every frame was evidence. Transparency cuts in every direction, and that is precisely why it matters. The fifth and final lesson is perhaps the broadest. Municipal accountability is not abstract. It is a financial and structural force that shapes policing policy. Cities that pay settlements of this magnitude face pressure from insurers, from city councils, from community organizations, and from their own legal departments to examine the conduct that created the liability. $3.7 million is a loud institutional signal. Whether it produces lasting reform depends entirely on whether the institutions choose to listen and whether the public holds them to it. So what should have happened on that December morning? The officer, upon seeing a garbage truck, a high-visibility vest, and receiving an immediate credible explanation, had every tool available to resolve the situation without incident. A radio call to dispatch, a request for work order verification, a brief conversation with a sanitation department supervisor. Any one of those steps, taken in the first 90 seconds, ends the encounter without an arrest, without a lawsuit, without a settlement, and without this documentary. The cost of that phone call was nothing. The cost of not making it was $3,700,000 and one man's life disrupted. Workers facing unexpected police contact should remain calm, identify themselves professionally, and make their purpose as visible as possible. They should not flee, not argue beyond stating their lawful position, and not physically resist under any circumstances. Their protection comes through the legal process, not through the physical confrontation that the legal process was designed to make unnecessary. As for reform, departments that implement de-escalation training anchored in Fourth Amendment literacy, that teach officers to investigate before they enforce, that create clear protocols for encounters with city workers and contractors on public property, those departments reduce their liability exposure and their community harm simultaneously. The reforms are not complicated. They require institutional will more than institutional resources. Authority in a constitutional system is powerful, but it is not unlimited. The line between enforcement and overreach is not drawn by volume or command presence. It is drawn by law. On December 22, 2024, that line was crossed. The bodycam recorded it, the courts evaluated it, and the city paid for it. $3,700,000 later, the lesson is clear. Investigate first, enforce second. Because when authority forgets its limits, the Constitution reminds it, sometimes at extraordinary cost. And this time, the camera did not just record the encounter, it recorded the liability.